Justice Gary Stein's career has encompassed a distinguished tenure of public service. I had the privilege of spending some moments with him 2 weeks ago when we were at the State House, and he was showing us some of the places where he's worked, some of the offices that he sat in, and some of the people that he worked with. It was impressive. He served in the New Jersey Supreme Court for 17 years, and during that time authored an unbelievable 365 thoughtful and well-reasoned opinions. Last month, my good friend Ralph Lamparello asked me to attend a speech at the Rutgers School of Law in Newark, the Weintraub lecture. I was mesmerized. Justice Stein spoke with such beautiful words. His speech impacted me, Ralph, and Angela Scheck so much that we knew when he finished that we had to have his words shared with us here today. So without further ado, Justice Gary Stein.
Good morning.
Good morning.
Ralph, thank you so much for that introduction. It's a special delight for me to be here today. I enjoy sharing this podium with Judge Simandl, Chief Justice Radner, Justice Holmes. Judge Simandl and I shared a law clerk, a young man who clerked for Judge Simandl in the district court, and then a year later clerked for me. He became the first comptroller of the state of New Jersey. His name is Matt Boxer, and he made us both look good. And of course, I never served with Chief Justice Radner or Justice Holmes, but we share a love and a lifelong commitment to the New Jersey Supreme Court and to the New Jersey judiciary that will never leave us. Justice Holmes mentioned the custom in our court of seating the justices by seniority, which sort of rubs a wound for me because I was the junior justice for the first 11 years that I served. In addition to the 7 authorized justices of the New Jersey Supreme Court, New Jersey's judiciary currently consists of 398 sitting judges. 215 are tenured. 183, or 46%, are not. Those sitting judges, during the last court term that ended in June 2013, resolved 954,751 cases, a work product of extraordinary importance to the citizens of New Jersey. The quality of that work product and the quality of those judicial decisions depends largely on the intellect, diligence, objectivity, and yes, the independence of those 398 judges, whom we expect to render decisions and resolve cases free of any fear of political pressure or reprisal. I want to briefly highlight the resume of just one of those 183 untenured judges who currently awaits renomination. He is a summa cum laude graduate of the Woodrow Wilson School at Princeton University in 1982. He graduated with honors from Harvard Law School in 1985. He served for 20 years as an assistant United States attorney, rising through the ranks to become head of the criminal division. He was then named Chief Counsel to Governor John Corzine, and in 2006 was confirmed as New Jersey's Attorney General. His name is Stuart Radner. He has served honorably, impartially, and independently for the past 7 years as New Jersey's Chief Justice. His qualifications for renomination are indisputable, and the fact that there exists today any possible question about his renomination as Chief Justice of the New Jersey Supreme Court should be a signal to every lawyer here and to every lawyer and judge in the state that the stature, the reputation, and the independence of New Jersey's judiciary is seriously at risk. The 1947 Constitution is the foundation for New Jersey's embrace of the principle of judicial independence. A Republican governor, Alfred E. Driscoll, in his inaugural address in January 1946, issued a call for a new constitutional convention less than 2 years after a proposed constitution had been rejected by the voters. When the convention delegates assembled, Governor Driscoll was invited by Nathan Jacobs, who went on to join our Supreme Court and who was the chairman of the Judiciary Committee of the convention, to address the Constitution's Judiciary Committee on July 10, 1947. His remarks on that occasion have a special resonance today, and I quote, Governor Driscoll said, "I would like to speak, if I may, very briefly on the following subjects. First and foremost, an independent judiciary. The separation of the judicial, legislative, and executive branches of government is essential to our freedom. It is, as you know, the courts that have traditionally been the guardians of our constitutions, to whom the poorest citizen may appeal for protection against a wayward executive or a capricious legislature. Without independent courts, the whole Republican system must surely fail. Our primary, our basic purpose in the drafting of a new constitution is to secure beyond any question a strong, competent, easily functioning, but always independent judiciary." The voters of New Jersey in 1947 were convinced that this new constitution, with its primary goal being an independent judiciary, was clearly in the public interest. At a referendum held on November 4, 1947, the voters overwhelmingly approved the new Constitution. The vote was 653,096 in favor and 184,632 opposed, a margin of almost 470,000 votes. To assure the independence of judges, that Constitution provided that justices and judges would be appointed for initial terms of 7 years and then reappointed to serve until age 70. The debate at the Constitutional Convention made it crystal clear that reappointment would be denied only to the rare judge whose initial term of service demonstrated that he or she was morally or temperamentally unfit. As one prominent senator observed, if they are qualified, they have no fear of not being reappointed. All of the governors who succeeded Governor Driscoll have adhered to the constitutional understanding that reappointment never would be denied because a governor did not approve of a justice's or judge's decisions. Prior to the denial of tenure to Justice John Wallace, 25 justices of the New Jersey Supreme Court, after serving their initial 7-year terms, were reappointed by the governor then in office. The constitutional understanding had been honored and preserved by Governors Minor, Hughes, Byrne, Kane, Florio, DeFrancesco, McGreevey, and Corzine. Governor Kane, who vehemently disagreed with certain opinions authored by the late Chief Justice Robert Wilentz, wrote that despite that disagreement, he knew that, quote, when the time came, no matter how much I disagreed with his individual decisions, I would reappoint the Chief Justice. The issue in my eyes, he said, was not Mount Laurel, but judicial independence. Governor Kane noted that since the 1947 Constitution, no judge ever had been denied reappointment based on court opinions or judicial belief. He added, quote, the day that happens, the New Jersey judiciary will be undermined, and I was not going to be a party to any such event. Those eloquent words of Governor Kane crystallize the very essence of judicial independence that was enshrined in our Constitution. It is the principle that a justice or a judge never will be threatened, pressured, or punished because his or her decisions are found to be objectionable by the executive or legislative branches. The framers understood, as all of us do, that governors and legislators may have profound disagreements with certain judicial decisions, but our Constitution clearly intended to protect judges from retaliation arising from such disagreements. Governor Christie explained that he refused to reappoint Justice Wallace because he disagreed with certain earlier Supreme Court decisions to provide greater funding for poor urban school districts. That explanation mystified many judges and lawyers who knew that Justice Wallace was not on the court when those early school funding cases were decided. In fact, Justice Wallace voted to uphold the state's position in the only 2 school funding cases he participated in. I was a member of the court that decided most, if not all, of the school funding decisions that the governor criticized, and I would suggest to you that that criticism is uninformed and unjustified. Without going into great detail, without going into great detail, the fact is that from the 1950s to the 1990s, this state turned its collective back on the state's urban school districts. And because their property tax bases had eroded after World War II, those districts could not spend nearly enough money to educate their children, many of whom were minorities and from disadvantaged families. The resulting disparities in resources and opportunities were documented. In a 93-day administrative hearing before Judge Stephen Lefelt, who heard 99 witnesses and admitted 745 exhibits, I doubt that the critics of the court school funding decisions ever read any of that record or read Judge Lefelt's 607-page decision, which found that shocking inequalities existed in programs, facilities, and instructional quality between New Jersey's richest and poorest communities. The state's richest districts were spending 40% more per pupil than the state's poor urban districts. In ordering that the funding disparity be corrected, Chief Justice Robert Willents wrote, and I quote, "If the claim is that additional funding will not help disadvantaged students to succeed, the constitutional answer is that they are entitled to pass or fail with the same amount of money as their competitors. If the claim is that these students simply cannot make it, the constitutional answer is give them a chance. The Constitution does not tell them that since more money will not help, we will give them less. That because their needs cannot be fully met, they will not be met at all. It does not tell them they will get the minimum because that is all they can benefit from. All of the money," he wrote, "that supports education is public money, local money, no less than state money. It is authorized and controlled in terms of source, amount, distribution, and use by the state. The students of Newark and Trenton are no less citizens than their friends in Milburn and Princeton. They are entitled to be treated equally, to begin at the same starting line. Today, the disadvantaged are doubly mistreated, first by the accident of their environment, and second by the disadvantage added by an inadequate education. The state has compounded the wrong and must right it." Our court never guaranteed, nor could it, that equal funding would produce equal educational results. But we supplement that funding by requiring full-day preschool for all 3- and 4-year-olds in the Abbott districts, an initiative being pursued today by Mayor de Blasio and many governors throughout the country, and that Abbott preschool program is widely regarded as the best preschool program in the nation. Our court's decisions guarantee fair and adequate funding to the urban districts. Implementation was left to the districts in the state. But the governors disagreed with our court's school funding decisions as a rationale for firing Justice Wallace, argues for a political philosophy closer to anarchy than democracy. A political system in which judges face removal for a court's decisions that displease or defy the executive branch is a system of judicial subservience, not judicial independence, and a subservient judiciary. A judiciary whose judges fear reprisal from the other branches of government is a judiciary that soon will lose the confidence of the public it is sworn to serve. That public rightfully expects that the decisions of judges entrusted to serve them will be grounded in principle, not compromised by political or other pressures having no legitimate bearing on the issues to be resolved. The removal of Justice Wallace sent shockwaves throughout the New Jersey judiciary. His removal was a defiant assertion that the 1947 Constitution's guarantee of an independent judiciary could be destabilized and even overruled by one governor who disdained the judgment of the framers. Governor Christie may have forgotten that most of the convictions won by his prior office of United States Attorney were in courtrooms presided over by federal judges appointed for life. His unprecedented interpretation of the governor's reappointment power would replace the stability afforded by the 1947 Constitution with a third world system in which his own appointees, Justice Patterson and Justice Fernando Vina, could be replaced by the next governor if he or she disagreed with their rulings. The governor's recent refusal during his re-election campaign to reappoint Justice Helen Holmes was as arbitrary and destabilizing as his rejection of Justice Wallace. Justice Holmes originally was appointed in 1994 as a Superior Court judge by Governor Christie Whitman and was elevated to the Supreme Court in 2006 by Governor Corzine. During her 7 years on the Supreme Court, Justice Holmes wrote opinions characterized by thoughtful analysis, extensive research and mastery of the record, and a capacity for pragmatism and clear expression. Ironically, in all of the court decisions considered to be most important to Governor Christie, Justice Holmes happened to vote to uphold the positions favored by the governor, joined in dissent in 3 of those cases by Justice Patterson. Those cases involved the challenge to a shortfall in school funding for the Abbott districts, the challenge to a statute increasing judges' pensions and health care contributions, the challenge to the third round rules of COA, the Council on Affordable Housing, and the challenge to the governor's reorganization plan abolishing COA. So why was she not renominated? The governor said he was acting in her best interests. To spare her a tough battle in the Senate on her reconfirmation vote. That explanation seemed incredible when it was revealed that Justice Holmes, as a state judge and justice, for 19 years, 7 months would have had a full pension with just 5 more years of service. Because she was not reappointed, her pension at age 60 will be 48% less than it would have been if she were reappointed. It does not appear to me that Justice Holmes' best interests were the motivating factor. In August 2013, during his re-election campaign, Governor Christie replaced Justice Holmes with Camden County Assignment Judge Faustino Fernandez Vina, a native of Cuba, whose appointment may have enhanced the governor's status with Hispanic voters. Because it was crystal clear that Justice Holmes was not replaced because of her judicial philosophy or her judicial decisions, the people of New Jersey are left to speculate on published reports that the constitutional framework for an independent judiciary may have been disregarded primarily to advance interests of a political nature. In addition to denying reappointment to 2 highly qualified justices with absolutely no history of leaning to the left in their judicial philosophies, this administration has taken other actions that undermine the constitutional design of automatic reappointment except for unfit judges. Members of the judiciary, of which almost 200 are untenured, understandably are anxious about securing reappointment because in most cases they had given up their law practice in order to become judges. Denial of reappointment, however rare, could require a judge to seek new employment unexpectedly and result in a loss of anticipated pension benefits. past administrations in New Jersey understood that dynamic and invariably arranged for early filing of the governor's notice of intention to reappoint judges whose initial terms were expiring. I know from firsthand conversations that several highly qualified judges throughout the state recently have endured agonizing delays and suspense when their reappointments were delayed until the 11th hour because of negotiations between the governor's office and senators over other appointments of new judges and other officials totally unrelated to the reappointment of the judges who were being left in limbo. In 2012, a highly respected assignment judge was not reappointed until 3 days after his term expired because of a delay in scheduling his Senate Judiciary Committee hearing, which caused serious concern about a possible loss of pension benefits. In late 2013, several judges whose reappointments were unjustifiably being held up were told to call their senators to try to expedite their reappointment. One judge I spoke to was so concerned about reappointment, she called her former landlord to see about the availability of office space to resume her law practice. All of those judges I spoke with were angry and resentful over being used as bargaining chips when under the Constitution, their reappointment should have been automatic and completed well in advance of their tenure date in order to alleviate unnecessary concerns. This practice of tying the reappointment of highly qualified judges to other unrelated nominations is cruel, it is wrong, it demeans and demoralizes the judiciary, and it violates the spirit and the major premise of our 1947 Constitution. I believe it's time to put a stop to the diminishment and demoralization of the judicial branch of our state government. One way to do that is by amending the Constitution to conform expressly with the intent of the framers. All that's required to accomplish that is a simple amendment to replace the first 2.5 lines of Article 6, Section 6, Paragraph 3 of the Constitution, which currently read as follows. I'll read it slowly for you. The justices of the Supreme Court and the judges of the Superior Court shall hold their offices for initial terms of 7 years, and upon reappointment shall hold their offices during good behavior. The replacement language would read as follows. The justices of the Supreme Court and judges of the Superior Court shall hold their offices for initial terms of 7 years, period. They shall be reappointed by the governor. Let me repeat that. They shall be reappointed by the governor with the advice and consent of the Senate unless they have demonstrated unfitness for such reappointment, and upon reappointment shall hold office during good behavior. That simple amendment would codify and make permanent the actual objective of the framers of the 1947 Constitution. The records of that Constitutional Convention clearly demonstrate the framers' intent that justices and judges who were qualified were entitled to reappointment, and only those who were morally or temperamentally unfit would be denied tenure. If 3/5 of each house of the legislature approve that simple amendment that faithfully reflects the framers' intent, the amendment could be approved by the voters at the general election this November. Ralph Lamparella, whose term as president ended last night, has been a courageous leader and an inspirational advocate for an independent judiciary. Both he and your new president, Paris Eliadis, support that amendment, and it's been endorsed by the trustees of the New Jersey Bar Association. What is required now is the support of the legislature. This amendment should not generate partisan or political division. It would protect the reappointment of Governor Christie's judicial nominees, as well as those of his predecessors. Besides, judicial independence is not a Democrat or Republican value, it's an American value. Justice Albin noted in a speech to this association last year that in our Declaration of Independence, one of the grievances cited by the drafters against King George was this, quote, "He made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries." So even King George was not above messing with the judiciary. Judicial independence, therefore, is a value that dates back to the very origins of our nation. It is a fundamental and indispensable part of our heritage and identity as a free people. Now, some have commented that a constitutional amendment is unnecessary because, after all, only one governor breached the Constitution's unexpressed understanding, and he won't be here forever. But once that constitutional bond has been broken, there simply is no guarantee that it will not be broken again in the future. Also, if we don't fix this problem now, 183 untenured judges will be left to wonder whether their judicial service will end after 7 years because someone with influence disagreed with one of their decisions. They deserve the security that this constitutional amendment would provide. They also deserve the support of the bar. And I urge any of you here who have good relationships with members of the legislature to encourage them to support this simple constitutional amendment. As all of our prior governors understood, the fundamental premise and objective of our Constitution was that judges should be insulated from all political pressures. Today, under the current policies, justices and judges fear for their reappointments. Untenured judges frequently ask their assignment judge to be excused from controversial cases for fear that their decisions will antagonize a legislator, an influential politician, or the governor's office. Before I joined the New Jersey Supreme Court, it was already held in the highest esteem. One constitutional scholar had described it as the best Supreme Court in the country, state or federal. New Jersey's court system uniformly was regarded as one of the best, if not the best, in the nation. I think the time has come to restore the stature, the respect, and the independence of the New Jersey judiciary by guaranteeing that qualified justices and judges need not fear that their reappointments can be jeopardized by improper political considerations. The citizens of New Jersey are accustomed to the confidence of having their disputes resolved by fearless and impartial judges. They need to have that confidence restored by the reappointment of Chief Justice Radner and by the adoption this November of a constitutional amendment that guarantees what the framers intended and what the people deserve